The ditch ran dry on a Tuesday morning in July of 1978. Clete Munger saw it before breakfast. He was walking the east fence line on his farm in Costilla County, Colorado, checking a section of wire he'd noticed sagging the day before. He looked down at the irrigation ditch mid-stride and stopped. Just cracked mud. A few dead moths stuck in the dried edges. The ditch had been running since May 12th. Steady and full, the way it ran every summer. Now it wasn't. He was 49 years old, had farmed this same ground since 1953. The ditch fed 2 alfalfa fields, 84 acres total. It also ran to the kitchen garden Dora kept behind the house. Without it, the alfalfa would be gone by mid-August. He walked the ditch north, toward the headgate. The headgate was the point where the water left the main acequia and entered his private lateral. He'd poured it himself in 1961. Concrete surround, salvaged steel slide plate. Still worked. He checked the slide. Up, meaning his headgate was open. The problem wasn't on his end. He kept walking north. The main acequia was dry. Dry for a quarter mile in either direction from where his lateral connected. The mud at the bottom of the channel had already cracked in the July heat. Plates of it curled at the edges like old paint. He kept walking toward the source. The acequia drew from the Rio Culebra. The creek came down off the Sangre de Cristos to the west. He walked to the draw point. There was a new diversion structure in the creek, about 200 yards above where the acequia pulled. Fresh concrete. Still pale on the surface, the way concrete looked when it was less than 2 months old. A large galvanized headgate was locked across the opening. Chain and padlock. Upstream of it, the creek ran full and cold. Below the structure, where the acequia should have been pulling, there was nothing. A metal sign was bolted to a post beside the structure. White paint. Black letters. Cisneros Livestock and Agriculture, Inc. Authorized personnel only. He stood in the July heat and looked at it. The name Cisneros was known in Costilla County. The operation had bought 4 ranch properties on the west side of the valley. That had happened over 7 years, one at a time. Roughly 9,000 acres total by 1978. They ran cattle mostly. Some hay ground in the river bottoms. Clete turned and walked back to his truck. He drove home, went straight to the barn. His father had built a cedar box with dovetail corners, worn smooth at the handles from decades of use. That box held the important papers: property deed, insurance records, and a manila folder, brown at the edges, that held his water documents. He put the folder on the workbench. His water right on the Rio Culebra had been adjudicated in 1912. The decree was 3 pages on heavy paper. A Costilla County court clerk had written it out in careful cursive. The court seal was embossed at the top right corner. His grandfather, Augusto Munger's name was on the first line. The priority date was 4 lines below it. June 4th, 1882. That was the date Augusto had first put water from the creek onto this ground. Under Colorado water law, the principle was simple. Earlier priority dates meant earlier rights. First in time, first in right. When there wasn't enough water for everyone, junior rights stood aside until senior rights were satisfied. June 4th, 1882 was old, among the oldest in that stretch of the valley. He drove to Trinidad the next morning. The county seat was 34 miles south on Highway 12. He went to the county water court records office. He pulled the filings for Cisneros Livestock and Agriculture, Inc. The operation had acquired water rights with each ranch parcel it purchased. The rights carried priority dates ranging from 1901 to 1947. Not one of them predated 1882. Every Cisneros right was junior to his. Junior rights could not be exercised when senior rights weren't being met. Colorado law had been clear on that since the 1870s. Cisneros had jumped the line. In July, the driest month of the year, he drove from the Water Court Records office to the Division II Water Engineer's office across town. The division engineer was Harold Finch. He had run the office for 11 years. Cleet had met him twice at Farm Bureau meetings. Finch was precise. He wrote things down before he said them. Cleet laid the folder on Finch's desk, showed him the 1912 decree, gave him the location of the new diversion structure, gave him the date the ditch had gone dry. Finch made notes with a mechanical pencil in a green notebook, said he would look into it. Cleet asked how long. Finch said within the week. Within the week was too long. Cleet drove home. He went to the equipment shed, found the submersible pump he used for frost protection in cold springs. He pulled it out, cleaned the intake screen, checked the impeller, carried it to the shallow well behind the shed, set it down the casing, and connected the power lead. 18 gallons per minute was what that well produced. The fields needed 40. There was no closing that gap, but 18 was better than nothing. He connected 180 feet of 2-inch aluminum irrigation pipe from the wellhead to the east field. He laid it on the ground by hand, joint by joint. Ran the pump. He did that every morning for 12 days. He was up at 5:30 each morning to check the pump and move the pipe. The aluminum sections shifted during the night from ground settling. He'd move the set, check the connections, start the engine, then walk the field while it ran. The south-facing slopes on the east field worried him most. That ground sat at the highest elevation on the farm, about 60 feet above the creek level. It was the hardest to water, even in good years. Without the acequia running, the pump barely reached it. He watched the alfalfa on those slopes carefully. By day 6, the color was wrong, a slight yellowing in the upper leaves. Not dead, just beginning to stress. He could count what it was going to cost. He'd been farming that ground for 25 years. He knew the numbers by memory. 12 days, $57.60. He kept the pump electricity receipts from the power company. He wrote the totals in his farm ledger on a separate line. He'd need that number later. It kept the worst of the east field alive. The south-facing slopes were already burning back by day 4. About 12 acres affected. The alfalfa on those slopes didn't die. But it was damaged. The stand thinned. The crowns stressed. He'd know by fall how bad it really was. Harold Finch came out on July 19th. He walked the acequia from the draw point down to Cleet's lateral. He photographed the diversion structure from 3 angles. He measured the headgate opening on the Cisneros structure. 36 inches. That was a significant diversion capacity. He documented everything in the green notebook and drove back to Trinidad. He issued the call on July 22nd. A formal written curtailment order, sent by certified mail and by hand delivery to the Cisneros Operations Office in Pueblo. Cisneros Livestock and Agriculture, Inc. was ordered to cease all diversion from the Rio Culebra until senior downstream rights were satisfied in full. The ditch was running again by July 24th. 23 days from dry to running. Cleet walked the east field that evening. He started at the north end where the slope was gentler and the alfalfa had held better. The stands there looked reasonable, stressed but intact. He walked south toward the higher ground. The 12 burned-back acres on the south slopes looked thin where they'd always been thick, pale green where they should have been dark. He pulled a handful of stems and looked at the crowns at the base, stressed, some dieback in the root mass. The crowns were alive, but not healthy. He'd know more when he cut the field in September. He could count what this would cost. 1 cutting in September, not 2. The second cutting was the margin in Castilla County. First cutting cash, second cutting profit. He estimated the loss at 58 tons of hay at $48 per ton. That was $2,800. That was based on his own records from the field. He had yield data going back to 1966. He knew what those slopes produced per cutting. He added 57 sixteeners for the pump, wrote both figures in the ledger. He drove to Trinidad the following week. He went to see James Archuleta, who had handled his property work since 1967. Small practice, 2 rooms above a hardware store on Main Street. Archuleta knew water law the way country lawyers know what matters in their county. He had handled 3 water disputes in the valley over his career. He knew the statutes. He knew which arguments judges in Castilla County District Court listened to. Cleet laid it all out. The ditch going dry, the new diversion, the engineer's call, the burned alfalfa, the pump costs, the 23 days. Archuleta asked 2 questions. Did Cleet have the 1912 decree in writing? Yes. Had the engineer formally documented the call? Yes. Then Archuleta explained something. He said the engineer's call fixed the diversion going forward. It did not compensate Cleet for the damage already done. What Cisneros had done was interfere with a senior water right. It had caused documented agricultural losses. It had forced Cleet to spend money mitigating an interference that shouldn't have happened. That was a civil cause of action under Colorado water law. Then he mentioned Section 3792-506 of the Colorado Revised Statutes. In a wrongful diversion action, the injured party could recover attorney's fees. But only if the court found willfulness, on top of actual damages, not instead of them, in addition. Cleet asked what willful meant in practice. Archuleta said it meant Cisneros knew it was diverting in conflict with senior rights, or that reasonable inquiry would have revealed the conflict. Cleet said it was hard to imagine not knowing. Hard to imagine building a concrete diversion on a creek without checking who else pulled from it. In Colorado, in water law country. Archuleta said that was exactly the question a court would ask. He told Cleet to give him 2 weeks. Archuleta filed the complaint in Castilla County District Court on August 29, 1978. The claims were clean and specific. Wrongful diversion of a senior water right, priority date June 4, 1882. Documented agricultural loss of $2,800. Emergency mitigation costs of $57.60. Total direct damages claimed $2,857.60. Plus a request for attorney's fees under Section 3792-506, plus a permanent injunction. It would require Cisneros to file its annual diversion schedule with the engineer's office. Any proposed diversion conflicting with the plaintiff's 1882 right required prior written approval. Before water moved, Philip Draper entered the case for Cisneros. His firm was in Denver. He handled agricultural and water litigation for large operations across Colorado, Wyoming, and New Mexico. He filed a motion to dismiss in September of 1978. 3 arguments. First, the engineer's call had resolved the diversion, so there was no ongoing harm. Second, the alfalfa damages were speculative, since multiple factors affected yield. Third, the plaintiff didn't qualify for attorney's fees. Archuleta opposed all 3 in a 14-page brief. He worked through 2 drafts over 10 days, filed it on a Thursday morning. On the first point, the administrative call stopped the bleeding. It did not pay for the blood already lost. On the second, Cleet had 12 years of yield records, kept in pencil in his farm ledger, field by field, cutting by cutting. East field south slopes, 4.8 tons per acre per cutting on average since 1966. The data was documented and consistent. On the third, Section 3792-506 authorized fees. He intended to establish willfulness. Judge Ortega denied the motion to dismiss in full. The case would proceed to trial. Discovery began in October of 1978. Cisneros was required to produce internal documents related to the diversion structure, planning records, permitting correspondence, internal communications from the months before construction. Archuleta's discovery request listed the date ranges and document categories precisely. He knew what he was looking for. He just didn't have it yet. The documents arrived in a box in late November. 37 pages total. Most of it was engineering specifications and contractor invoices for the diversion structure. Standard project documentation. Archuleta went through the box himself on a Saturday afternoon. He found what he was looking for on page 4 of a folder. The tab was labeled Capital Projects, West Valley, 1978. A memorandum, dated March 14, 1978. From the operations manager of Cisneros Livestock and Agriculture to the company's principal, Ernesto Cisneros, in Pueblo. The memo discussed the proposed Rio Culebra diversion structure. It stated that the operations team had reviewed county water court records prior to planning. It listed downstream appropriators by name and priority date. The oldest date on the list, June 4, 1882. Clete Munger, 84 acres, Costilla County. The memo then recommended proceeding with the project. 3 sentences explained the recommendation. It said downstream right holders were small single-operation farms. It said the Division II Engineer's Office had historically been slow to act on complaints from small operators. It said the disruption to downstream users would likely be brief. The memo described the probable cost of any legal action that followed as manageable. 3 sentences, written in the same businesslike memo format as the rest of the document. No different typeface, no hedging language, just the recommendation and the reasoning behind it. Archuleta read those 3 sentences twice. He set the memo on the desk in front of him, sat back in his chair. He thought about the word willful. He thought about how much work he had just been handed in 3 sentences. He made a copy, drove out to the farm that Friday afternoon, set the copy on the kitchen table in front of Clete. Dora brought coffee without being asked. Clete read the memo once, set it down flat, picked up his coffee cup. He said he'd like to proceed. The trial was held in April of 1979. 3 days in Costilla County District Court. Judge Raymond Ortega presided. He was a careful man, took notes throughout in a blue cloth-covered binder, asked questions before witnesses stepped down. Philip Draper had driven down from Denver. He had 2 associates with him. They sat up at the defense table with 3 boxes of documents. Archuleta had 1 box and a cardboard tube holding the overlay maps. Archuleta laid in the foundation first. The 1912 adjudication decree, admitted as Exhibit A. The engineer's curtailment documentation, Exhibit B. The 12 years of farm ledger yield records, Exhibit C. The pump electricity receipts, Exhibit D. The March 14th memo, Exhibit E. He called a water engineering expert from Colorado State University. The professor specialized in high-altitude irrigation systems. He testified on the effect of 23 consecutive days without irrigation on an established alfalfa stand at 7,800 feet elevation. In a dry July, daytime temperatures during the 23-day period had averaged 87 degrees Fahrenheit. At that temperature and altitude, established alfalfa crowns showed measurable damage within 14 days. Root mass density declined. Stand recovery required 1 to 2 full seasons. He calculated the expected yield loss on the affected 12 acres at 3.4 tons per acre per cutting. At $48 per ton, the missed cutting was worth $1,958.40. Combined with reduced stand density going into the following season, total documented loss, $2,800 as claimed. Philip Draper cross-examined Clete on the second day. 2 hours. He questioned rainfall during the 23-day period. He had records from the Trinidad Weather Station showing 3/10 of an inch of precipitation during the gap. He argued that rainfall had partially offset the irrigation loss. He questioned whether the pump had further reduced the claimed damage. He questioned the alfalfa variety's drought tolerance rating. He questioned whether stand loss in the south-facing slopes might have a different cause. A pre-existing soil condition, perhaps. Something unrelated to the irrigation gap. Cleet answered from memory throughout. He had farmed that ground since 1953. He knew the yield on every field, every section, most cuttings going back to 1966. He knew the south-facing slopes had averaged 4.8 tons per cutting in normal years. He knew the rainfall during the gap hadn't reached the root zone in meaningful amounts. He knew the pump had helped, but couldn't close a 22-gallon-per-minute deficit on 84 acres in July heat. Draper did not shake the yield records. Draper also raised the chain of title question. The original Munger homestead had been subdivided twice since Augusto's time. He argued the 1882 priority date might not carry to the current acreage configuration. Archuleta had prepared for that. He produced a continuous chain of title going back to 1882, from Augusto Munger's original entry to Cleet's current deed. Every conveyance had included a specific transfer of the water right. Priority date intact through each transaction. Judge Ortega issued his ruling on May 8, 1979. He found that Cisneros Livestock and Agriculture, Inc. had willfully diverted water from the Rio Culebra, in conflict with the plaintiff's senior priority right. Priority date, June 4, 1882. The diversion had caused documented agricultural losses of $2,800. Emergency mitigation costs of $57.60 were compensable. Both figures were awarded in full. He also found that the March 14, 1978 memorandum established willfulness beyond reasonable question. Cisneros had reviewed the water court records. It had identified the plaintiff's senior right by name. It had proceeded with construction regardless. That was the definition of willful under the statute. Under Section 3792-506, willful interference entitled the plaintiff to attorney's fees. He awarded them. Archuleta's total fees for the case, $4,840. Total judgment, $7,9760. Cleet had asked for $2,5760 in damages. He received $7,9760. The ruling also included the permanent injunction. Cisneros was required to file its annual diversion schedule with the division engineer's office. Deadline, May 1st each year. Any proposed diversion conflicting with the plaintiff's 1882 right required prior written approval from the engineer. Violation of the injunction was contempt of court. Draper filed an appeal in September of 1979. The Colorado Court of Appeals heard it in February of 1980. The opinion came down in May, affirmed on every point. The memo was sufficient to establish willfulness. The fee award stood. The injunction stood. Draper did not seek further review. The case had taken almost exactly 2 years. Cleet found the dry ditch in July of 1978. The Court of Appeals ruled in May of 1980. 2 years, 10 months, and 3 weeks. Cleet received the check from Cisneros in early June of 1980. He drove to Trinidad and deposited it at First National Bank on June 12th. He noted it in the farm ledger. One line, date, description, amount, $7,697.60. No other notation beside it. He used $4,200 of the judgment on the headgate. Replaced the old wooden slide plate with a machined aluminum plate. Added a stainless steel operating stem and yoke. The 1961 concrete surround was sound. That stayed. Just the moving parts needed updating. The new gate opened with one hand instead of two. He put $800 towards certified seed alfalfa and reseeded the damaged 12 acres that fall. By the summer of 1981, those slopes were back to full stand density. Both cuttings, normal yield. The rest went against the operating note at First National. Word moved through the county slowly and without fanfare. Through the Acequia Association meetings in March, through the feed store in La Veda, through fence line conversations in the spring when neighbors ran into each other on the county roads. Cleet didn't speak about it in any detail. Archuleta mentioned the outcome carefully in the context of advising clients who had water questions. 3 other small operations in the valley had experienced Cisneros diversion conflicts in 1977 and 1978. 2 families had not pursued anything. One had filed an engineer's complaint, but left it there. After Ortega's ruling, all 3 reached out to Archuleta. He filed 2 additional actions in the winter of 1980. Both settled before trial. Settlement terms were sealed. Both families had water the following season. Cisneros Livestock and Agriculture filed its annual diversion schedule with the Division Engineer's Office every May 1st. For the next 11 years. Never missed the date. The form was 1 page. Priority dates listed in order, oldest first. June 4th, 1882 appeared at the top of the list every year. Cleet farmed the ground until 1994. He was 65. He sold to his nephew Robert Munger that spring. Robert had worked the farm for 3 years by then. He knew every field, every gate, every irrigation set. The sale included the land, the equipment, and the water rights. The 1882 priority date transferred with the deed. It always had, going back to every conveyance since Augusto Munger's original entry. Cleet sat at the kitchen table the morning of the closing. He read through the adjudication decree one more time. The same folder, the same 3 pages of handwritten cursive, the same court seal at the top. He put it back in the box when he was done. He had farmed that ground for 41 years. The ditch had run every summer of those 41 years, except 23 days in July of 1978. He handed the box to Robert at the closing. Robert's wife bought an archival sleeve at an office supply store in Trinidad in 2001. The paper is clean. The court seal is still visible. Augusto Munger's name is still on the first line. June 4th, 1882 is still 4 lines below it. Robert still farms the 84 acres. Still irrigates from the Rio Culebra. The aluminum headgate Cleet installed in 1980 still works. Opens with 1 hand. The water still comes. It has since 1882.